The law is a much older profession than accounting. Its roots can be traced back to Greco-Roman times. England, which has had so much influence on the law in English-speaking Canada, was influenced by Roman tradition after the conquest. But the law developed differently in England than on the continent. As any of you who have been to Niagara on the Lake recently and wandered around, you know that the Law Society of Upper Canada was founded there in the late 18th century. Early in the 19th century, it moved to Muddy York, now Toronto, and in 1830s, Osgoode Hall was built. Today, like everything else, the law is seeing change. Paralegal licenses, the bar admission course is being replaced by the licensing process, and so on. And the big law firms seem to be following the example of the large accounting firms with partners in many, many cities and indeed in many countries. As an undergrad, I wanted to become a lawyer but could not afford 4 more years of university, so I went into management consulting where I made as much money and didn't have to spend the 4 years. That's supposed to be humor. A little pause, please. While some accountants claim that their profession dates back to early Mesopotamia, I tend to think of it as being born in Florence in 15th century as a result of the work of Luca Pacioli and his famous book on double-entry bookkeeping. To this day, there is far greater interest in the history of accounting in Italy than almost anywhere else in the world. In accounting, as in law, British practice was followed in Canada. While a national body was not created until early in the 20th century, Jim's, Heather's, and my old firm, P.S. Ross & Sons, began practice in Montreal in 1858. Ross's accounting business originally focused on balancing books. An early part of the accounting business was calculating taxes as a result of the protective tariff. Another part of the business involved dealing with insolvencies. There is an apocryphal story that Sun Life, one of our early clients, paid their first audit fee with a life insurance premium. P.S. Ross helped establish the first professional body in North America in Montreal in 1880. The creation of the Securities Exchange Commission in the United States in the early 30s had a profound impact on the accounting profession, and I think it led to our present situation of the Big Four. You may recall that President Roosevelt appointed Joe Kennedy, father of John, as the first chairman of the commission on the theory that it takes a crook to catch a crook. As an undergrad, I never wanted to be an accountant and never thought I'd end up spending 30 years with them. Not as an accountant, as a consultant. So that tells you a little bit about the profession. I'm not going to say very much about the two gentlemen here other than they're legends in their field. Jim Baillie was, of course, a senior partner in Torys LLP, which is a respected international business law firm based in Toronto. Jim has served on many boards, indeed has resigned from some, and has been chairman of the Ontario Securities Commission. On a personal note, Jim is recently married, at least by my standards. What may shock you is it was a first marriage, and I think that's intriguing. And then the other thing, Jim and I are the members of the same book club, and I discovered there are two kinds of people. There are people that only read one book at a time, and there are others who keep 3 or 4 on the go. Jim reads one book at a time. Now, I find it slightly harder to describe Jim Goodfellow as a legend because I've known him so long. Jim is a maritimer by birth. I'm so old I met his father before I met Jim. Jim joined the Montreal office of Touche Ross when that was the major office for the Ross firm, and then the Touche Ross firm, transferred to Toronto and was vice chair of Deloitte after Touche and Deloitte merged. Deloitte Canada is based in Toronto in that beautiful new building on Adelaide Street and is part of the international firm of Deloitte Touche Tohmatsu. I will do my very best to keep this session moving, but it will be difficult. These are both animated individuals, and we've got far too much material, and so we're not going to leave the questions to the end, but encourage you to ask questions as you go along. And Jim, over to you. And do you want me to change the slide?
Yeah, why don't you do that? Thank you, Joe, on behalf of Jim and I, for the opportunity to participate in this session. And let me just underscore again what you said, is that we don't have a Q&A session. Okay? So please join in the discussion, interrupt, let's talk about the issues as we go through. And we really would like this to be more of a conversation than a presentation. Here's the way we're going to organize the thing, is that we've broken the material up in 150 years into these buckets or periods. Okay? And we use these periods because these periods correspond to the time frames in Joe's book. Okay, so and for each of those time frames, what we're going to do is we're going to ask Joe to just set the context for that period, kind of thing, and then Jim and I are going to talk about the developments in securities regulation, governance, accounting, and those things within that time frame. So that's the way we're going to kind of move through the thing. When the time is up, Joe's going to go over this and say, "That's it. On to the next time frame." So we'll keep us marching through the piece, so that's our game plan. Before we get into those, there's a couple of sort of stage setting issues that we'd like to talk about. Joe, why don't we flip over to the next one? Okay. Because that's what, Joe, you talked about, the influence of the countries. Jim Bailey's going to talk a little bit about, first of all, because started here, the influences in corporate law and really of the UK, the European countries, and the United States. Because as we go through all of these periods, you're going to find out that, all of those countries, that the emphasis shifts as we go along from one period to the next. So, Jim, do you want to?
James, you promised not for the first time, perhaps a little more than I can deliver. I thought one of the important themes to my mind, perhaps the most important theme in Canadian corporate law today, ties back to, in my mind, as I think of it, to a question I had in law school. We studied the Solomon case, which some of you may have heard of. I won't bore you with the details, but it's the British case which is cited always in law school as the precedent for the decision about limited liability. And on that acorn, a mighty, mighty oak has grown of our whole corporate law system, predicated not on any analyzed, deep-thinking Royal Commission report or careful, detailed discussion, but rather on this one case, which in the great scheme of things doesn't count for much. And in consequence of that method of growth of our law, we have a structure which at the basic law looks to the shareholder. And the issue that I consider to be terribly important, and perhaps the most important issue in corporate law today, is what the responsibility of the public company director is in considering big corporate decisions. The law doesn't give much. Oh, I brought something.
A prop.
I hope it will impress you with the sheer dedication and quality and energy of our corporate lawyers. Anybody who studies the law is supposed to know about this if he wants to be in the Bank Act area. That's the Bank Act. a few guidelines, regulations of toughness. And it says to the directors that they must have so manage or supervise the operation of a bank, and elsewhere it says that they must manage it in the best interest of the bank. Well, that's just about zero guidance in the statute, and the general law has evolved to say, I think, the BCE case in the Supreme Court of Canada raises some nice questions about it. But your primary interest is the shareholders, unless the corporation is in the vicinity of insolvency. Well, in this day and age, that's plainly not an acceptable criterion. So we have developed a lot of things, oppression remedy, class actions, activist institutional investors, and so on, to bring pressure on the board. But still, the basic law is this concept of the best interests of the corporation, which is a legal fiction. So you have to operate the best interests of a legal fiction. And that makes it very hard for the directors in many cases, and very hard for corporate lawyers who are advising them, as I say, all built on the basis of the Solomon case. The British have addressed this. They addressed it in 1966, I think, by an elaborate statute which requires that the directors consider the interests of employees, the need to foster the company's business relationship with suppliers, the impact on the community and the environment, the desire to maintain a reputation for high standards of business conduct, the need to act fairly as between members. I don't know if that makes it easier or more difficult, but at least it recognizes that directors have a wider responsibility. The reference to the European model, of course, is in Germany in particular. There's an elaborate corporate structure which says that there's a supervisory board which gives the employees some representation in decisions. I guess my only reason for this, my particular pitch, in the BCE case, thoroughly complicated the law in Canada. I will talk about it for anybody who wants to provoke me, but it's a decision that, where I think, with respect to the court, the Supreme Court of Canada reached the correct result. Extraordinary. A unanimous Supreme Court of Canada decision overruling a unanimous Quebec Court of Appeal decision. Quite an extraordinary situation. But the Supreme Court of Canada and its reasons complicated the law in this area a lot. Anyway, I'm simply saying that our modus of operating by largely impinged by case decisions and then remedies on a narrow, focused basis to address aspects of those case-by-case decisions, I think sometimes has produced regrettable results in this whole area of securities and corporate law.
Yeah, Jim.
Can I just make an observation on that, Jim? Kind of related. I mean, the concept of limited liability, if you think about it, it's kind of amazing that there's a concept of limited liability. I mean, most people don't have limited liability in life for what they do in life. And the business corporations develop this idea of limited liability. It's not like being a partner where you're,
right.
As a law partner, if things go down, you go down with it, right? But the limited liability company, which has totally changed the way business can be done, and by the way, it's something that can be abused mightily by the particular agents that are carrying it out. So,
yeah, but it's great. As a former law partner, I can testify that I welcome the introduction of limited liability as a law partner. So, at that point, we're carrying on the business. It's great.
So if you look at that slide, let me just point point you to the other side of the slide, because this is one of the things that Jim and I want to bring out in the course of as we go through these 3 years time periods. Our securities regulation and accounting and issues are shaped not just by sort of the legal or the accounting thought process, but also by business cycles, crooks, events, all of these kind of things that play in, political pressures, all of that. And in each time frame, these are different. And the different things emerge. And so, if we can bring anything to this sort of conversation, is that Jim and I have both practiced, in his case law, in my case accounting, for over 40 years each, I think, which is a lot of practicing. When you think of it. We both, Jim has sat on the chair, in the chair of the OSC. I've chaired the Accounting Standards Committee. We both advise boards, work with boards, and we've both been on boards, been working on audit committees. And so we can tell you that this, this is a dynamic process that shapes our securities regulation and accounting. It's all factors like this, and that's what we're going to try and sort of highlight as we go along through this process. 2 things to keep in mind as we're going through this. One is that the securities regulation challenge and the accounting challenge is really kind of in 2 ways. One is investor protection. How do we protect investors as we go through this? And the second is, how do we ensure that the markets are efficient and operating effectively? So you've got both the investor issue and the market protection issue. With that, Mr. Martin, let's go.
Here's the economic context. You can read that as well as I can, but let me make just 3 points. Before 1867, 3 years before, the Fathers of Confederation met in Charlottetown and Quebec City and agreed that in Canada, as unlike the United States, banking would be a federal responsibility, which is why we've ended up with that big, thick Bank Act. The second thing everybody is most familiar with is Sir John A. Macdonald's national policy, which he was able to start implementing in 1879, of a protective tariff, a railroad to the Pacific, and settlement of the West. And then as this period ended, the latter part of the 19th century, you had the wheat boom began, which so powerfully shaped Canada in the early 20th century. Over to you, Jim.
Yeah, so let's go to the next slide. In terms of securities regulation, governance, and accounting in those days, the interesting parts there is that you get the establishment, Joe, of the Federal Bank Act and a superintendent of insurance. No superintendent of banks at that stage, but a superintendent. Now, with respect to securities, though, Mr. Bailey, we don't have anything. We have stock exchanges get formed and start operation. And with respect to disclosure, the Canada Joint Stock Companies Act, the requirement was the directors of every company must lay before the shareholders a full, clear, and printed statement of the affairs and financial position of the company at or before each general meeting. No specification of what that is. Okay, so in some cases, it was a narrative explanation. Some cases, it was just a balance sheet. Everybody was entitled to interpret what that was. As Joe said, the focus of accounting those days was a lot on balance sheet, safeguarding assets, really a control issue kind of thing. I should also, Joe mentioned P.S. Ross setting up the firm. The interesting piece was P.S. Ross, Philip Ross, came to Canada to get into the ship chandling business. He was a ship chandler. When he arrived in Canada, in Montreal, he found out that in the winter, the St. Lawrence River froze. And the ship chandling business wasn't too good. So he went into accounting. And that's how we got there. So anybody could move in, the knowledge came from the UK, just like in the UK law, and so that's all. Jim, any?
Yeah, the only comment we're on this historical section, and I probably would not be inaccurate if I said you and I are history right now. And at the start of both our careers, the law was still embodied in these general statements of which you speak, almost guidelines, and great responsibilities rested on professional advisors to construe for their clients what was appropriate within the range of those responsibilities. The role of professional advisors, at least in my profession, you can speak to yours, the role of professional advisors has changed enormously. In the latter part of my career, people would come into my office and say, I want you to do such and such. And I'd say, can I do such and such? They say, oh yes, there was a case that I found in the internet that happened 2 years ago, and there's a new law over here. And of course, I just want you to do it. I don't want you to tell me whether I should do it. And it was a very different relationship which evolved through my time at the bar. And Jim, you at least in your profession had the whip hand because you could give or withhold an audit opinion. But still, I won't speak to how your profession paralleled mine, but there was an utterly different kind of relationship and practice towards the end of my career as it was towards the beginning.
Absolutely. I mean, I can think back, and Jim, back to when we started out, the senior partners of the day, their relationships with their clients was a very different. It was a business advisory, a much higher level, and it changed over time. Those sort of very senior level business judgment thinker, and their business acumen as well as their command of their technical knowledge, and it becomes much more technical.
Yeah.
Okay, let's go, Joe.
Just like to make 4 brief points here. The century began with this enormous wheat boom, and the West was settled. In the Great Depression, I think it should be noted that in spite of thousands of bank failures in the United States of America, there were no bank failures in Canada. Throughout this period, you were seeing the shift of the financial center from Montreal to Toronto. Toronto had won the Battle of the Bank Acts during World War I, when there was an immense amount of bond financing. Most of the bond financing was done in Toronto because of the Minister of Finance, not in Montreal. And then in the Great Depression, because Toronto was much more oriented to mining than Montreal was, and gold exploded in price thanks to FDR, Toronto surpassed Montreal as a stock exchange. So while a lot of people don't look at the shift from Montreal to Toronto until the 70s, in the fact it was well underway by 1950. And the last point I would make is 1947, Leduc was discovered. In a 5-year period, as we just heard in the last session, not only had Imperial Oil sold off all their South American assets, but in 5 years, Canada moved from being a net importer of oil to a net exporter of oil, and our oil companies became truly integrated as they searched for oil as well as marketed it.
Okay, let me say a couple things about accounting. I'll turn it over to Jim to talk about boiler rooms and blue sky laws and the Securities Acts. The first bullet, 1907, that was significant because that changed the dynamic from the previous year. The Ontario Companies Act made a big step forward at that point in time. They specified what needs to be provided to the shareholders: an income statement, a balance sheet, a report of the auditors. And not only that, they put in the act, here's what the balance sheet should contain. And so it's specified. So that was like a huge, all of a sudden now, boom, there was something that was specified. The next thing is, look at the fourth bullet down, the Temporary Income War Tax Act. Look at the date. That's 100 years ago, folks. The Temporary Act is now 100 years old. Now that has a big impact on accounting and reporting, because suddenly you were taxing income. And you had to say, well, what's income? What's allowed in income? What's an allowed expense? how's revenue to be run? So suddenly you have a whole question of issues of the definition of getting into what constitutes income. And the second piece is you get the government and the accounting profession starting to part ways, because government uses that definition for incentives and public policy and this kind of stuff, and the accountants are trying to figure out what is the logical thing that defines what's in income and what's not. A whole whack of accounting firms emerge at this point in time to sit up to try and help address the question of what the heck is in income. Okay? The next piece is, let me drop down, is down to the bottom. 1939, the profession starts issuing bulletins. Now that's to try and help its members. To say, here's how inventory should be accounted for. Here's the rules for this. Here's the rules for that. And they start issuing bulletins. That creates a tension between the issuers and the accountants, because the CICA has no ability to, or no authority to set accounting for the issuers. All they can do is to their members. And so now the company says, well, what do you mean, Goodfellow, I can't do this? And I say, well, you can't do this because there's a bulletin. I'm not allowed to sign your statement if you don't account for inventory this way. So tensions start to it. Third part is the New York Stock Exchange and the SEC recommend the board should set up audit committees. That's the first start. It's not a requirement, it's a recommendation. And leading companies start to do that, but it takes a while. Jim, boiler rooms, blue sky laws.
Jim, and I'm very grateful to him for it, prepared these slides. Among the reasons is that I don't know how. But he allocated to me, after this broad brush review of the world as developing, I get boiler rooms. But let me tell you, boiler rooms were important in Ontario. They were important in shaping the reputation of the province in the United States and elsewhere. They were important as a constant burden for the regulators, because George Drew had emerged by then as the first, later Premier of Ontario, had emerged as the first securities regulator. I think he was a one-man shop. But these boiler rooms resulted in constant complaints. And when I was chairman of the OSC in 79 to 80, they were still on deck as a constant complaint. And
Jim, does everybody know what a boiler room is?
Well, I'm going to give an example. The example is a guy came in who had been sold moose pasture stock. Anybody not know what a moose pasture is? Sold moose pasture stock by a boiler room. That is, the calls emanated, and the belief was that these salesmen were all in boiler rooms downstairs in the bowels of the buildings. But it had been sold moose pasture stock by somebody in a boiler room, and then, of course, the market vanished. The stock was worthless. He lost all his money, and he called up the boiler room to complain. And he tape recorded the conversation, and the conversation started out with bitter complaints and ended by his buying more stock. That was these were just an enormous impact on the perception of the investment industry, and we took years to get out of it. There was a report.
Excuse me. I think you should just add that the boiler rooms were really interconnected to the promotion of mining stock in Ontario.
Absolutely.
The mining booms up in
And
the north and throughout the entire country. So
and the report, I think is mentioned here, the Urquhart report, which came out in 1944. In the war, they had time to spend on this issue, and it was a mining report, mining commission, Royal Commission, and it diverted to talk about boiler rooms. And they carried, because the whole focus was how do we get more mining entrepreneurial capital in this province. And diverted, talk about boiler rooms, and characterized the securities markets at the time as, quote, something in the nature of a jungle, close quote. And that got the whole area of securities regulation given an incentive and an area to move. Does that deal with your point adequately?
Well, oh, yeah, no, it's good, the connection, and of course the Texas Gulf kerfuffle in the early 60s.
Yes.
So all a lot of the boilerplate juniors ended up being banished to Vancouver, to the Vancouver Exchange, because the TSX wanted to be a little more prim and proper.
Which has some implications for a topic we're coming to later,
Yeah.
the National Securities Commission.
Okay.
I think did everybody see the movie The Wolf of Wall Street?
Yeah.
Yeah, that's a boiler room. You know, it's the whole 3 in 1 is pump and dump. You know, you pump the security. It could be a mining stock. It could be a concept. It could be whatever. You pump it. Then you get out and you dump it, and you're gone when the market crashes. You've made your money, and everybody else is left.
They're still doing it in Vancouver, from what I hear.
We're going to come back. This is, and the bottom line, which Jim's point is you know, we were really good at it. You can question the morality of it, but these folks were good.
Stephen?
Yeah.
Okay. I think there's a point worth making here. I mean, when we're talking about crooks and so on, we're talking about the obvious ones, okay? But business and public morality has evolved over time.
Yes.
And it was much different in 1900 than it was in 1950. I mean, we started out talking about, you know, the board of directors was supposed to look after the best interests of the corporation. Well, views of what was allowed in 1950 wasn't what was allowed in 1900, and that these things change. And these are some of the key issues in the development of Canadian business that really need to be studied.
Yes.
You know, and how they were directly influenced. I mean, how they were directly influenced, say, by the introduction of income tax, and suddenly everybody had to have standard accounting. You know, or there are various cases. I can think of one case that I'm hardly an expert on. Just as a word of introduction, I was the business archivist at Library and Archives Canada for more than 20 years, so I got to look at material that nobody else has ever looked at, okay? But in terms of best interests of the business corporation, the First Dominion Textile Corporation Company was set up in 1905, okay, in Montreal. And it was a merger of, the end merger of a whole series of mergers. But in 1905, some of the, or shortly thereafter, some of the minority shareholders took the board to court because it didn't think that their best interests were being looked after. Okay, and this case was fought all the way to the Privy Council in London. Okay, and the board won.
What year was that?
Hey?
What year?
Well, it was between 1905 and 1910. Okay, and the board won, and you know, was the today some people would say, well, that was a big setback for the average shareholder. Okay, but I mean, is there any kind of literature on this, or because this happened in Montreal and hasn't happened sort of in what has become the home of Canadian business history in Toronto? Why it hasn't been studied? Because it happened in Montreal and not in Toronto?
Well, that's a good enough reason.
Hey? Yeah. Well, that's what I thought somebody did. So, I mean, these are the kinds of things that among the things that I think need to be looked at is sort of how boards of directors, individual members of boards, how sort of they behaved over time, how that changed.
Yeah, and
It's very much worth looking at.
my opening intervention was designed in part, you've covered it more succinctly and focused way better than I did, But part of the point I was trying to make was that in our system, these things evolve through judicial decisions, a little bit through reports, but the practice, I agree with you, ethics have improved, but the practice and the standards are always a little bit behind the laws, behind the reality. You know, I'll digress. A partner of mine, I believe an older partner of mine, such people existed, told me that when he went to London way back when on a deal, prospective significant business deal, the lawyer he retained in London, while he was there, picked up the phone, called his broker, and bought some stocks. And maybe the same would happen today, but it would be through. And you know, it's a change of business ethics and evolution over the years.
Very good point. I guess one of the things, too, is out of this session, we're not historians.
No, I understand.
But we're hoping that maybe through this we can stimulate ideas and people to pick up on your point of saying, hey, this is worthy of further research. I think this whole piece that Jim started out on, but then the whole how the directors act, and I know as a director, that's one of the struggles, is how do you really always act in the best interest of the corporation, where there's so much pressure to act in the best interest of the shareholder. And so anyway, that's a great point.
Go ahead.
I think so.
All right, I'd just like to make a few points here. Certainly, the early part of this period, if you were a young person, it was remarkably easy to get employment. I mean, it was a really good time. Another important economic development was this is when the oil sands really started to come into play back in the early part of this period. The auto Pact is a very important turning point in '77, and Michael Bliss, who I spoke about this morning, book Northern Enterprise, he said that this showed that Canadians were able to manufacture, and that suddenly, rather than being an importer of automobiles, we became an exporter of automobiles. And to do a slight riff on your part, Stephen, when you move from the hinterland to Toronto, as I have, you sort of accept the fact that this is a center. But I'm going to go into the two Jims territory. When I remember, I was executive assistant to the Premier of Manitoba in the 60s. We had 1.5 people in Securities Regulation. No Atlantic acceptance paper was sold in the province of Manitoba with 1.5 people in the regulatory body.
That was a good 1.5 people.
Did you want this one now, or?
Yeah, so there's one other development that happens in this period of time, 1950 to 80. That's the first part of this chart. This chart is the prime lending rate, and that is inflation. Okay, and you can see I used, rather than the CPI, I used the lending rate because we can understand that's what your best customers get. And so you can see in the period, Joe, about just after 80, the prime lending rate is up around 22%. Mortgage rates are above that. Okay? That's what the best customers get. Okay? Now, there's 2 or 3 pieces that I'd like to emphasize in this. One is that, you know, Mr. Bailey's alleged that Paul Volcker is the hero for solving this. Okay? Well, the real hero, Jim, is the bean counters. Okay? The real hero is the bean counters, because this is what was happening.
Wow, we're boasting now.
So let me explain. So here's what I was doing back in that business. I was running around, but all my clients were saying, I'm making a ton of money, and I have to keep borrowing more. How does that happen? Well, here's the simple example. Suppose you buy something for $8. You sell it for $10. But then you've got to replace it. Okay? So you go to replace it, and you've got to buy it for $9. So how much profit do you make? You know? You make $2. Of course, the government says you made $2 and taxes it on $2. Okay? But in cash terms, you only made $1. You pay taxes on $2. So consequently, you're going to keep it to the bank. So the accountant said, we'll fix this. We'll change the accounting rules. So you only made $1. Business said, what? We like putting out to our shareholders that we made $2. They were, yes. So it was actually, while Jim was at the OSC, I was in the Accounting Standards Committee, okay? We're putting out this standard. All of the business community was up in arms. Up in arms. So you know what they did? They stopped raising prices so they wouldn't have to implement the rules. And so therefore, the bean counters actually solved the accounting problem, not a fact you probably didn't. Remember, Jim, this is the world of fake news and alternate facts.
I just didn't know it started so early.
Anyway, that was a huge issue. But here's, Steve, to others, and tying back, I think, to the session that you had yesterday on running points of history. And I'm keying off your reactions when I put up that, and so you say, wow, kind of thing. We have a whole whack of executives down here, okay, that have had their whole business experience in a world of decreasing interest rates. Okay? And we're in a period of time when interest rates can't go any lower, and the central banks are going to get out of their quantitative easing programs, and there's a lot of dynamics that are going to be going on. And if you haven't paid attention to what actually happened back here and how you deal with that kind of thing, you know what's going to happen? These guys are going to reinvent the whole wheel again. And probably reinvent the problems along with it. So I don't know, Jim, if you want to pick up on that, or from the session yesterday, or.
Yeah, well, I just want to emphasize, parts of what you just went through are accurate, Jim. And certainly one part is the importance that, given, I remember the hectic meetings, and I got involved in some of them, pressuring for a new guideline on inflation accounting, which was going to make some fundamental changes in generally accepted accounting principles. It was treated as an urgent item, and then suddenly the fizzle went out of it when Volcker did his thing, and in fairness to you and the bean counters, the accountants did their thing, and the wage price controls came in. But it was an urgent issue, and the lesson, apropos your remarks yesterday, Joe, is that we're in danger of forgetting it.
Right.
It left very little literature. It left no change in the accounting guidelines, and it will be treated as a brand new, never before occurring problem when it happens again.
Yeah. There's a great study, I can't remember the author, but on bank failures, 400 years of bank failures. This time it's different, and and the answer is this: no, it ain't different. These things keep reappearing, and the cycle keeps, and we never seem to learn. So that's the piece on inflation accounting. If you go then, Joe, to the next piece, here's the changes that occur. And Jim, you and I were talking at the coffee before. This period of time here was a change in, I believe, in a change in fundamental repositioning. The Securities Acts get changed. Jim will talk about that. I'll talk about the accounting. One of the drivers of that was your collapse of Atlantic acceptance. And the collapse of Atlantic acceptance had an impact because A, it was big. B, it was a structurally set up, so they had a parent and a whole whack of subsidiaries that were doing various things. In terms of the audit profession, they had farmed out the audit of all of the subsidiaries, so there was the issues of reliance on other auditors and all of this kind of thing. Questions were raised about what the board's oversight. A call was made in the follow-up to audit committees for audit committees to be set up. So that had stimulated a thing. Also, on the accounting side, what happened is in 1968, the CICA then replaced the bulletins. Remember I said the bulletins were being set up for the members? Okay? They replaced the bulletins with a handbook split between accounting and auditing. Next thing that happened was National Policy Statement 27 is issued by the Securities Commissions. which says to the issuers, because remember the bulletins were to the members of the CICA, okay? National Policy Statement 27 says, issuers, you must follow the recommendations in the handbook. So, and then that gets incorporated then into, I think, Jim, into the Securities Act of 79 in Ontario and the other Securities Acts and Corporations Acts. That then gets incorporated into the securities legislation, which says that for the purposes that generally accepted accounting principles means the recommendations of the handbook. That's like huge, because that in effect is the delegation to a private sector organization for setting the regulations to act. Huge responsibility to the CICA as to how you deal with that. Different than the U.S., where the U.S. said, SEC, you're responsible, kind of thing, and through that you invite a lot of political involvement in standard setting. So that's kind of like very significant change goes on in this period of time. And I think also, well, over to you, Jim.
Well, just one small comment on that, Jim. In public policy terms, in terms of principles and concept, you might wonder if this delegation of vast authority to a private sector organization, but it's like Churchill's comment on democracy that it's the worst possible system except for any other system you can devise. I think this system has worked. It has produced. It would nightmare if you even conceive for a second of our securities commissions deciding accounting policy, with Saskatchewan doing a different set of policies from Ontario and God knows what. And the United States Congress regularly interferes in the setting of accounting policy. So I think it's a heck of a good result that the accountants do it. This is national uniformity first, and then, as we'll probably come to later, international uniformity. I think we're blessed that system emerged, even though it does delegate huge power to the one profession.
And I think part of the thing is that the oversight committees that were set up, which Jim, you chaired on the audit, putting in the governance processes and all of that kind of stuff has been helpful. Jim, talk a little bit about the Securities Act, the change goes in the shift from the traditional sort of focused on the prospectus to continuous disclosure comes in.
Well, that was probably the most, when I was in the chair, the legislature put through the new Securities Act, and there were a lot of changes in it, but probably the most important, most contentious was the concept of continuous disclosure. And in that environment, the one that I got most heat about was a definition of material fact, which some of you have encountered. We tried to make the distinction between a change in the environment as a whole, which companies didn't have to disclose, and the change in the circumstances of the particular company, which did have to be disclosed as by a news release or whatever. And I faced big rooms full of people. They didn't happen to have any ripe tomatoes on hand, but if they had, I would have been the target because people did not like that change. I think it's worked all right, but there was a huge change in the securities law and the corporate regime of requiring current disclosure of material changes in material facts.
The other thing that happens in here is that in 1970, I think it was, in the Ontario Business Corporations Act, audit committees are required. And then that appears in the Securities Act. So audit committees come mandated. Now, then, of course, you had a period of time where people say, well, what does actually an audit committee do? It says they've got to have one, but what do they do? And we'll see that we have a sort of a learning period through the I guess, Jim, through the 70s and 80s, as audit committees struggle with this, and the lawyers advise them, accountants, all lots of advice, what you do, kind of thing. And then it really gathers momentum in the 90s and the 2000s, so we'll come back to that. So audit committees take the next step. Remember, in the 40s, the New York Stock Exchange recommends them. They then get established, and stay tuned in the next time frame.
Well, I guess the major change here is from the 50s to 80s. Let me tell you, it was easier to be a manager than in this next period. Management became very tough. In the early 80s, we had a sharp recession, worse than in 2008. In early 90s, there was another recession. So you had those issues to deal with as a manager, which you hadn't had to deal with for a while. The FDA agreement in the election of 1988, I get a sense that there's some upset in Canada with the way Mr. Trump is talking about NAFTA, but I have no, it was a very passionate issue in '88. I mean, the debate between Prime Minister Mulroney and Opposition Leader Turner was one of the most emotional debates I've ever seen, and I think, without a doubt, that Opposition Leader Turner won, and that put the free trade people into a panic, and the dean of this school really got on the road, John Crispo, and helped sell free trade at that time. But since, I mean, now you get I almost get a sense that the majority of Canadians think free trade is a good deal, but let me tell you that was not necessarily the case at the time. Then as you ran to century end, we had that weird experience, which will be a footnote in the history books, about the dot-com boom bust around Y2K. Everybody thought the world was going to come to an end because they hadn't programmed the computers to go into a next century. It didn't happen. So the NASDAQ boom went to the NASDAQ bust, and only in this past year, past 12 months, has NASDAQ reached the levels it had at the turn of the century. Next one.
Just to pick up on the dot-com boom bust thing, I can remember, Jim, back in those days going to various boards and audit committees and conferences, and I was trying to convince companies that they should pay attention to cash flow and earnings. And, of course, that was not where the focus was. I can remember being on a panel and the moderator said, "Jim, you just don't get it. You're the old economy, we're the new economy." See? And he said, what you're talking about earnings and cash flow, what you really need to be focused on is EBE. I said, EBE? What the hell is EBE? He said, earnings before expenses. And that was the focus. Earnings before expenses, like eyeballs on screens and all of this kind of stuff that went on. And when you think about it, Jim, back to the boiler rooms, this was just another version of pump and dump. And you had all of these things that you had a great concept, this is going to make a lot of money, IPOs, stock options, all of this stuff went in, and then it crashed. So the dot-com crisis was a lot of learning there. I think the only other piece here, if you get to the challenging slide beyond here, is that you have a whack of failures in this period of time. In the U.S., you've got the savings and loan crisis, and a whack of company food, and there's a lot of skullduggery along with that. And Lincoln's Financial was one of those pieces, and others that really got a high profile of what the owners, the managers were up to. Same thing happens in Canada. We wipe out the trust companies. 3 Western banks go down. CCB, Northland, and British Columbia. So
And 2 in Eastern Canada.
And 2 so they go down, and you have Confederation Life. So there's a lot of bank failures, kind of thing. There's a lot of the Estee report, particularly, makes recommendations. OSFI concludes that one of the root causes of the failures was poor corporate governance and weak internal controls. Estee says the Inspector General is aware of these and failed to act. Now, the response in Canada and the U.S. is different. The Canadian response, Joe, is really to strengthen OSFI and put that with the U.S. They put out new legislation around the savings loan. So they said for every federally insured depository institution, you got to do several things. One, the CEO and CFO have got to certify on the financial statements that they're a fair representation. Two, they've got to certify they have proper internal controls. Three, the auditors got to attest to those internal controls. And four is all of these organizations got to have an audit committee of the board of directors to oversee both management and the auditors. Now, remember those four things, because I'll give you a hint. They reappear in the next decade. So that's...
Jim, let me ask a question to the two of you. It seems that somebody pointed this out just to me past week, that in contrast to OSFI and the strengthening of OSFI in the 90s, you had the Greenspan put in the United States. That's an enormous difference.
Right.
Okay?
Huge.
Of course, the Greenspan put benefited Canadian investors as well as U.S. investors.
Right.
Yeah. Okay, Jim, observations from you on this?
Many. You want to talk about ABCP or do you?
No, let's we got a slide. We'll come to that.
I don't think I have much to say. This was a busy time. For me personally, it was a very busy time. But you'll say the root cause of those bank failures, of course, was the inability to raise the cash on the other side of the balance sheet. They had lots of deposits, but they didn't have the balancing cash, and the institutions weren't prepared to. The big institutions weren't prepared to trust them with the cash. I think the government did a pretty darn good job of keeping continuity and finding a home for them, and I think Bill Kennett deserved more credit than he was given. But that's, I don't want to tarry on that.
I agree with you.
And I won't disagree with you, although I do. But it seems to me, and this, I don't know if we've had too many business historians in the room, but there's a phrase in history about path dependency, and a number of scholars have written that Canada followed a path dependency right up to 2008. Well, I think the 1980s, Canada was anything but path dependency. We went from a relatively lightly regulated system to a supervised system, and that, to my mind, was a big difference, and one of the reasons Canada did much better in 2008 than we did, than the Americans did. And the other reason was, I think there were still more guys around in the financial corporations who remembered how bad the evaluations were on the LDC loans, and so that they had a better sense and feel for what was coming.
Yeah.
Okay. Didn't we just do that? Or did we?
I think we're now into...
This one?
Yeah, let's... well, I think go back one, Joe.
Okay.
Overtime.
Yeah, let's talk a little bit about... So this slide looks at the changes in governance and audit committees in that period of time. And you can see that there's a whack of studies that go on, and some of them pretty... Starting with the Cadbury report at the top in the UK, that has enormous influence. Cadbury comes out and says, here's the principles of good governance, and the regime is to comply or explain. Okay, it's not a regulatory mandated. You don't have to comply, but if you don't comply, you should explain why. Peter Day picks that up in Canada, does a study, and comes out with the Day report on where were the directors. You have the Asian crisis and long-term capital management, which creates more than a minor ripple through the whole thing. You've got the blue ribbon report on audit committees in the United States that says here's what audit committees should be doing. And you've got the banks who then split the roles of the CEO and the chair. I think that has a huge impact on governance in Canada, and and right now, Canada has, I think Jim has far more in Canada. The vast majority of companies have now split the role of the chair and the CEO, whereas the U.S. most of them are still combined.
Yeah, and it goes beyond that, Jim. It's a very interesting phenomenon which goes farther in Canada than in either the United States or the United Kingdom, and that is reliance on outside independent directors. The big thing about the audit committee was that, from the beginning, from the time it was the first studies, I think from the beginning, maybe there's a transitional thing, but the audit committee is entirely outside directors. And that has gradually caught on, and this is a bit historical causes, but more right-thinking people said this was the way to do it. With the CEO being the only executive member of the board. Many companies have that structure these days. I disagree with it. I think it's bad. I think that having the CFO or some other senior officer on the board, in addition to the CEO, and having the ability to speak up as of right, instead of waiting to be called on by the chair, I think it can be very valuable. And I'm sorry that we've lost it in many public companies. But the audit committee started that, the board carried it on, and then gradually other committees, especially compensation, sometimes corporate governance, are assuming a role which is maybe not as important as the audit committee, but the importance of their topics is coming to be recognized. And I'll comment on one other thing we were going to cover tonight, because we might not have time, is the role of outside advisors is another topic that needs some more careful discussion and review, and the tendency of directors to unload some important decisions onto, not just lawyers I shouldn't say just lawyers, not only lawyers and accountants, but HR advisors, compensation people, intellectual property advisors, on and on. And they are really playing a very important role in this new regulated environment of which you speak.
Right, and I think, Jim, if you jump through, just to build on what you're saying here, you get, of course, to Enron and WorldCom. Okay? So the background on there is Enron, we all know, but Enron goes down. Congress is pressured into a response. It's led by Mike Oxley with Paul Sarbanes, except that it's driven by Oxley and it's a governance-like approach. It's all ready to go through Congress, and then WorldCom goes down. When WorldCom goes down, things shift. Sarbanes now becomes the driver, and you end up with Sarbanes-Oxley, which was much tougher than what the Republicans wanted to put in. George Bush has no change. He signs it right away. And you've got, and what is Sarbanes-Oxley? CEO certification, management certification of controls, auditor attestation of controls, audit committee requirements. I happened to have a chance to get to know the guy who was the chief of staff to Paul Sarbanes, and I said to him, how did you guys ever, under that pressure, come up with this piece of legislation? He said, we went back to the savings and loans crisis. We lifted that legislation up, changed it around, dropped it in. So the savings and loans response is the basis of what Sarbanes-Oxley is. Okay? Same thing. Now applied to all public companies. Canada responds, adopts basically the same rules as the audit committee, sets up a different structure for the audit regulators in Canada, the PSID, because it's and pulls off an amazing coup to get that set up without legislative requirements, kind of thing. adopts a different approach to internal control and adopts the same approach to certification. So there's a Canadian response here. Out of this whole period emerges, as Jim has said, a whole governance industry starts to emerge. There's gurus appear. There's advisors appear. Proxy advisors appear. All sorts of advisory firms, compensation advisors appear. Kind of thing, and a whole kind of industry emerges around that, which is kind of that, all of the advisors, and that's what we're now kind of living with as we move on in a period of time. So this is a pretty, from a governance point of view, this period of time is pretty dramatic in terms of the change that occurs.
Well, one thing just to compare with the U.S. and Canada, I was down at the Harvard Business School in the late 1990s, and we were having the whole discussion around separation of the president, chairman, and CEO, and Quinn Mills was leading the discussion, and he was justifying all three together. And so I said, look, I'm a Canadian. You're the country that came up with separation of powers. Why would you have separation of powers in the public sector and not in the private sector? He said, oh, that's very simple. I said, well, explain it to me. I don't understand. He said, well, he said, in the United States, in business and in the military, we want to get things done. The last thing we want is for the government to do anything. That's a true story. And, you know, Jim was saying some very proud Canadian things, but he neglected to mention that long-term capital management, one of the two principles, was a Canadian.
Thanks for bringing it up. Okay, we're galloping through, yeah.
In that time, could you comment a little bit about the pressure on auditors in terms of testing to determine financial statements? I mean, there was that point at the time you're getting paid by the company to, and what happens when you find something, that tension between here's our audit fee.
Yeah. So yeah, the auditors are squarely in the Sarbanes-Oxley thing. The auditors are in the crosshairs. Okay, and the issue becomes one of consulting work, consulting for clients versus doing audit work. The interesting piece on Enron is that Arthur Anderson, who were the auditors, didn't do any consulting for Enron. When they, in their disclosure, was all their other services were all audit related, but yet they were blamed for being, you know, providing consulting services, but they didn't do that. The mandated internal control, two things happened there. One was in the Sarbanes-Oxley legislation, one piece of that is they take the right to set auditing standards away from the profession, and they give it to the PCAOB, which is a subsidiary of the SEC. So it's a government control thing. So they give the auditing standards mandated to the government. They set up a regime that is hugely bureaucratic and hugely costly.
Their rules became very prescriptive.
Very prescriptive, and it was the government. So it was the government. They take away the standards. The government issues the rules. Okay, business objects. In Canada, the Canadian business looks south of the border and say, "Oh my God, we don't want any part of that." So in Canada, we adopt a regime that is management will report on internal control, and there will be no auditor attestation. The United States, over time, sorts itself out. So I think now the auditor reporting on doesn't seem to have nearly the fire and brimstone and concern it had, and I think it's actually produced some very, very good results in terms of improving controls and this kind of thing. But in Canada, we take a different approach. It was really tough for the auditors being in the middle of all of this in terms of trying to, in the U.S. case, trying to implement rules that have been set by the government, and yet being blamed for the rules, kind of thing, and the costs associated with that. So does that answer your?
Yeah, it was not only internal control, but even from accounting principles point of view, wasn't the debate in the U.S. accounting principles at the time, like they were being faulted because they were too prescriptive in
Well, they're too prescriptive, and they're too prescriptive in the one hand and too lax in the other. Because one of the things that was the cause of Enron was the off-balance sheet entities. Okay, so they permitted all of these vehicles that were set up that Enron used to generate income. They placed their executives on those off-balance sheet entities, which enriched the executives. So that whole off-balance sheet sham was a big part of the scheme, and so that was a blame on the accounting principles. So there's lots of, I mean, that was a huge amount of chaos at that. If you remember back, I mean, the market plunged, it was all churn, and the ship got righted eventually, but it was pretty wobbly at various points in time.
Yeah, the thing I would add to that, I won't touch the auditing side, but the accounting side, the position of the partner on your audit is terribly important, make very important judgments. And not everybody realizes that practically every, there are corporate directors here who would disagree or agree with me, but practically every significant judgment of a public corporation is preceded by extensive discussions with the accountants and with the credit rating agency. And those two inputs are essential in these big decisions. And the judgments that the accountants and the credit rating agencies make on what the corporation is proposing to do, how it's going to be treated in accounting terms, how it's going to be treated in terms of credit rating, are enormously influential. And you really are dependent on good people being in those two slots and making good judgments.
And the issue back to your raise on the accounting.
I think we got to keep moving.
Perfect. Let's go to the next one.
There it is.
Good. Okay, we have two more pieces. One is stock exchanges, and the other is asset-backed commercial paper, and I think we got something on the executive.
National Securities Commission.
So, James, National Securities Commissions.
Now?
Are we going to go right to that?
Yeah, I think, first of all, because I think you have a great regulating a stock exchange must be like one heck of a challenge.
Yeah, Jim, I went through this. I mean, but the first thing to remember is that, like the accountancy profession, in Canada is national, which is an enormous plus. The Toronto Stock Exchange, whatever you say about the quality of the regulations and whether it's a monopoly and whether it should be a public company, which is, to my mind, a very controversial issue. Those are all issues with pros and cons, but at least it's national. And so you have uniform rules across the country. And yes, the stock exchange is hard for a regulator of one province, as I was for a time, to control, to regulate. Its resources dwarf those of the Securities Commission, or they did then. The Securities Commission has more resources now. And they speak for the private enterprise and for the free market, and that's always hard to counter when you have disagreements. But I have to say, overall, I think our Canadian stock exchanges do a pretty good job. I'm sorry they haven't evolved something for effective and open and transparent trading in debt securities. That's, I think, badly needed in our country. But overall, I think they've done a reasonable job, and as a risk of repetition, at least they do it on a national basis. Now, I didn't think you expected me to say something else, and I've forgotten what it was. So, pretty important.
So about the National Securities Commission.
Well, do you
Yeah.
go right to that?
Well, do you want me to speak on that? I haven't got my blood pressure up. I think there's a desperate need for a National Securities Commission, and I personally think that the federal government, or the then Minister of Finance, supported it. The support seems to have disappeared under the present government, but really serious need. The problem, I think, was presented by the government and argued on the basis of prospectus clearance. And as somebody here said earlier, giving Saskatchewan and the Atlantic acceptance as an example.
Manitoba.
Manitoba, was it? Atlantic acceptance never got into Manitoba. There's a legitimate, to my mind, a legitimate interest of the provinces in regulating or having some control over what securities are sold in the province, under what rules, the dynamics are, and so on. And so Ontario did a Ricard Commission way back when, regulating the mining. That's a legitimate interest to my mind, and I think the system is working reasonably well. I think that the passport system, which has developed over the years, it's expensive, pays a lot of money to the lawyers, but that's not all bad. And it operates reasonably quickly, reasonably effectively, and gets the deals cleared. And there was too much emphasis, I think, given to that when they were looking for a federal commission. The places where it desperately needed are international dealings. Ludicrous. I've never been to one, but I've heard a great deal about the IOSCO meeting, International Association of Security something. And you have United Kingdom, United States, France, and then Ontario, Quebec, and I understand Alberta's joined up now. It's ridiculous. And so you need a national cohesive body on the international side, desperately needed on the criminal law side. The confusion, there was a very good conference here in this building on the problems of criminal law enforcement resulting from the disparities. And I won't go through all the details of the fascinating conference, and nobody, as far as I can tell, has paid any attention to it since. Good papers done and so on. The problems are legion, serious, and we don't have proper enforcement of our criminal law in this area by any means. That and one or two other areas, I think there's an appealing public policy case for a National Securities Commission, and if the federal government had focused its fire on those aspects and said the prospectus clearance could take care of itself, I think we'd have a National Securities Commission today. But that's only one guy speaking. I got my blood pressure up.
Well, you're in fine form. I would happen to agree with you. I was a director of a company, a small cap company, and chair of the audit committee, and when I joined the board, found out that we were regulated by the province of Saskatchewan, and after a year, I said, we got to get out of here, get to Ontario,
But it's been argued, it's been decided by the Supreme Court of Canada, so what?
No, I don't think the decision focused on that.
And there's a second reference that's going to.
Sorry?
I think there's a second reference question that's going to go up to the Supreme Court. Because
They
heard one in
Quebec.
Yeah, from Quebec. Yeah, they had one this spring.
right.
That the Chief Justice heard with was a panel of 3 this time, rather than the panel of 5 in 2011, and so it's going to go up to the Supreme Court for sure.
And I haven't studied that decision. I should have, but
Which one, 2011 or
going back to the original decision? I thought that the door was open. They looked, the federal government tabled the whole Securities Act, Ontario Securities Act, marked it up a bit, presented to the Supreme Court, and the Supreme Court said no. But there were some paragraphs at the end of the decision about there being an opening for other things, international jurisdiction, criminal law. Those are clearly federal powers.
There's also a cooperative arrangement,
Right.
so that would be broadly across the country.
I think in those areas, the federal government, God knows what the Supreme Court would do. It's the unpredictable court in the world. But in those areas, international law, criminal law, I think the federal government could barge right in and take over.
Jim, this is far from my area of expertise, but I was speaking in Winnipeg not that long ago, and Sandy Riley was in the audience. And as you know, Sandy was, amongst other things, former CEO of Investors.
Yeah.
And his great concern is that what he stated is he felt that if it became Ontario, they would be much more concerned with the issue of the issuer and facilitating issuing of of securities than the protection of the investor. I'm just throwing that
But
out.
I've said that, I carved that out.
Yeah.
If Manitoba wants to regulate and control what insurers come into the province of Manitoba to spew out securities, God bless.
Okay.
I think that's a legitimate interest of Manitoba. But the whole, not the whole, but a very substantial part of the debate on a federal securities commission revolved around that question.
To me, one of the pieces of the concern I have is, will our system in the present time, how will it deal with systemic risk and the changes that are occurring in the capital markets and the technology, and all of these kind of things? Will this fragmented system will we be able to attract the talent and put the investment in order to keep pace and deal with that? And I just can't see that happen. And a good example, so let's now go to the asset-backed commercial paper, which I think was the previous one. Yeah, okay, because we put this in as a bit of a case study. It's a thing that actually pulls together, we think, a lot of the issues that we've been talking about this morning, and it focuses back on the issues of the regulation of a new product and a new market that emerged. And so you have this thing where you get in Canada, 32 billion of short-term paper gets frozen. And I can remember going, when it's frozen in mid-August, and all public companies in Canada were, of course, in their third quarter. So by the time you got to October, when you had to report on this, I was going to a bunch of, this was my last year before I retired, so it was kind of stuck in my mind. And going to audit committees and that. And I can remember going to a company and to an audit committee meeting, and the chairman opened the meeting this way. He said, the first item on this agenda is for the CFO and the treasurer to explain why we are making a $15 million provision against our cash. Because that's usually unusual. We don't make provisions against cash. And the reason was they have 15 million of asset-backed commercial paper, the non-bank asset-backed commercial paper. And the treasurer quickly explained, he said, well, the reason we have a provision against 15 million cash is that this board authorized management to buy commercial paper that was AAA rated, blah, 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 blah. And it was as good as cash. And that's why it was in cash. So what happened? You get behind the scenes. It's what happened. You get this whole market evolves. The non-bank asset commercial paper gets exempted, Jim, from the prospectus requirements. So it was exempted from. They get the role of the credit rating agencies. As long as it's AAA credit rated, it gets exempted. And it also then gets rated as investment grade for the buyers, kind of thing. The investment community is pushing this out. There's something like, I forget, well, Paul, you would remember, it was 15,000 retail or 1,500 retail investors, something like that. The city of Hamilton,
on the retail side.
Yeah, on the retail. City of Hamilton has this stuff. I had a church fund that had this stuff. I mean, it's spread all over the place. Kind of thing. There's no transparency. Nobody knows what's in it. It takes Purdy Crawford and his committee months to try and figure out what's in it, and they find out that there's U.S. subprime mortgages, but most importantly, there's credit default swaps and in here, and so there's no transparency. They're all promoted through a off-balance sheet vehicle, so that appears again. The banks are involved in this. They concoct a Canadian guarantee process. Two of the U.S. credit rating agencies say we're not going to do this. DBRS ends up as the only one doing it. OSFI is involved in this so that it keeps it off the balance sheet of the banks so they don't have to pay additional capital. Jim, this pulls together everything. Who's in charge? Nobody's in charge. And I think, James, this is more than a minor mess.
was great, Aim. By the way, if anybody wants to get into it in more detail, and I recommend this be done only with a good stiff drink beside you at the fireplace at night. But if you can stomach it, I highly recommend Paul's book, which is the only book I know of.
It's on sale upstairs.
Sorry?
It's on sale
Well,
upstairs.
it's on sale upstairs. That's great. It's a terrific recon with it.
After that introduction, who would want to read it?
I'm not sure.
If he's writing it, I could understand.
I had to swallow hard. I took it chapter by chapter. Very, very effort at will, because everybody comes out badly. Everybody comes out badly. The investment dealers, the investors, because this was a desperate grab to have your surplus cash. It was sold as a way to get a higher yield on your cash reserves instead of a bank deposit. It was sold that way.
Right.
And anybody who thinks they're going to get an absolutely safe higher yield on their bank deposit, it has to be questioned. The audit committee should have questioned them. Investment dealers should have questioned them. The credit rating agencies, God knows, should have questioned them. The only thing I'm going to comment on, if I may, Jim, is the court ruling. Because that's a lawyer's territory. There was a totally, Paul, you let me know if I misstated. The court ruling, they had to do a ruling under the Winding Up Act.
It's double CAA.
Double CAA, okay. Companies creditors range for that. It had to be a court ruling to approve the final deal that Purdy Crawford and his advisors put into place. And the banks that were involved in issuing these horrible pieces of paper said that, well, they're going to lay a condition down to cooperate in the settlement. I mean, they should have been desperate to settle. They should have, got rid of this mess. But no, there was a condition. They had to be absolutely assured that nobody could ever sue them. And the judge went for it, and Purdy Crawford's group went for it. So there's an extraordinary. I think it might be unique. Certainly, I hope there aren't many other examples. The court made a ruling that nobody, and this includes people not before the court. Most court rulings only apply to the parties before the court. There'll be a lot of parties, they're all bound, but people not before the court are not bound. This court ruling said nobody can ever sue the banks and other participants in this ruling. I thought it was terrible, just disgusting, but it was necessary to get this very poor deal through. Anyway, I've had my second rant, Jim.
Do you want any response, Paul?
No, he's absolutely right. The legal releases went to everybody, credit rating agencies. Anyone who touched the paper, looked at it, was absolved. And the argument was that they'd have cascading suits if they didn't have that. So somebody could go after, the credit rating agency would go after somebody else, and they would just be locked up in this kind of problem forever. They were only locked up for 2 years, the way they did it.
Close time. 12:15.
One final observation. I can't remember, these numbers may be wrong, but Lloyd Blankling of Goldman's gave a talk way back in the middle of all of this and made this observation and said at the time of the financial crisis, there were something like 10 or 12, I think, that order of magnitude, of AAA rated companies. Global. Right? That's the number of 10 or 12 AAA rated companies. Kind of thing. And there were 25,000 AAA rated products. What's wrong with that picture? And there was, from the auditing point of view, absolutely zero independent auditor involvement in any of those products. Right? People added the so the lessons here are huge, and they covered all of the things we've been talking about this morning in terms of pump and dump. This was another pump and dump.
This is the ultimate pump and dump.
This was the ultimate pump and dump. So, prospectus, etc. I say a whole piece here. Tons of lessons to be learned in this. We have one other slide here dealing with executive compensation disclosure. I think let's just summarize that. There is a really good example, again, of where intense political pressure comes to bear. The issue is escalating levels of CEO comp. The solution is, if we disclose it, that will ensure, that will curtail growing It actually produces, Jim and I think, actually escalates executive comp kind of thing. So the law of unintended consequences, and an interesting conflict that Jim brought out is the conflict then between the Ontario and the public sector. We go to the Sunshine List, and actually Jim has the opposite effect.
Yeah, I think it's actually it's regrettable, because I think what's happening in Ontario is the people that the government really wants to attract are not being compensated as much through direct compensation as through enhanced pension benefits, chauffeur, God knows what. So they don't show up in the list of the $100,000. You don't show up as much. Anyway.
And because you weren't here last night, I don't believe, Jim Leach was asked the question, what does the future hold in pension plans? Is there a danger that the public sector with very good pension plans and the private sector with lousy pension plans is going to lead to some sort of clash in society? And he said, I think so.
And, and that's why people they'll be talking about draining the swamp type of thing.
Right, precisely.
Right?
Yes.
Stephen, one last question, and we got to.
Okay, well, just one last comment. I mean, you both amply demonstrated why business history matters. But I just wanted to amplify that. Since I'm retired, one of my prerogatives, of course, is getting up late and having my coffee late. And a couple of weeks ago, I turned on BNN, and there was some talking head saying that 35% of financial advisors in Canada were not in the business in 2008.
Who?
So God help us.
So, I had one final rant.
Okay.
Can I?
Sure.
Can I give 45 seconds of my
Yeah.
final rant, and then the rant is about well, as Jim in his remarks has well indicated, we in Ontario, we claim, in Canada, claim we don't follow the United States, but in fact we do. We might deal with the issues a little more differently, but we look to the United States for ideas and for guidance and so on. And so but in one terribly important area, in my mind, the United States doesn't provide a precedent because it doesn't have the problem, and that is small companies, tiny companies by U.S. standards, doing IPOs and being listed on the public market, and often with multiple voting shares to perpetuate the control of the controlling shareholder. And I have no strong position on anything that should be done about this situation, except I think it's a very important situation. And the only people who are dealing with it are consecutive chairs of various securities commissions across the country. I tried, tepid kind of way to deal with it when I was chair. My successors as chair all tried to deal with it. But he can't. It's a national issue. It's a terribly important national issue. It should. The securities commissions aren't the right forum to be addressed yet at all, and certainly the provincial securities commissions can't possibly cope with it. It raises questions about whether this is a proper use for investors' funds. It raises questions whether these companies should be public at all. It raises questions about the methods by which the founders perpetuate their control. And I don't take a position at all on the merits of what should be done about it. I just say it should be addressed, it should be thought through, and there should be some sort of cohesive policy on it. And there can't be, while we looked so much south of the border for our ideas and our identification of areas of concern, and while we're operating on a provincial securities commission basis.
Now, I think Jim,
There's my final rant.
So, and that's a nice segue, because there's a really good book coming out called From Wall Street to Bay Street by Chris Kobrak and Joe Martin, and they point out that we look to the south and they never looked north, and maybe it's time they did. With that, I'd like to thank you, the people who attended this session. I'd like to especially thank the legendary two Jims. You were outstanding. And once again, thank Heather from Deloitte for sponsorship.